Hello and welcome to the HOA Show, where we discuss the news, problems, trends, and critical issues relating to life in a homeowner association. Join us every episode, and together we'll explore how to survive and thrive in the dizzying world of HOAs.
Hello, and welcome to the HOA Show. I'm your host, Ryan Gazelle, and this episode we'll be discussing the legal updates from 2024. I'm joined today by Louis Brown and Steve Tinley. Louis Brown is a partner at Consors and Conway, managing its Sacramento office and government relations group. He specializes in helping clients navigate California's complex legislative and regulatory processes, having written numerous laws and playing key roles in negotiating legislation and regulation on a variety of topics. Since 2017, Louis has been the legislative advocate for the California Legislative Action Committee of CAI. He holds a BS from Cal Poly San Luis Obispo and a JD from McGeorge School of Law. Steve Tinley is the managing partner of Tinley Law Group, providing general counsel representation to many of the firm's larger HOA clients throughout California. He's very active in the industry, being a featured speaker, author, and educator for various industry events and media outlets, as well as having served as president of the board of directors for the Orange County chapter of CAI. He received his undergraduate education at USC, we'll forgive him for that, and then later obtained his JD from UCLA, which we approve of, where he focused on corporate and real estate law. Thank you both for joining us today.
Right on.
Louis, before we begin, could you explain what it is that you do for CAI?
Definitely. Thank you, Ryan, and appreciate you inviting me to be on with you today. Yes, Community Associations Institute is an international organization, and they have chapters throughout the world, but in the United States, chapters in each of the different states. And so we have the California Legislative Action Committee. We're a committee of the national organization, and our job is to address issues from a legislative and a regulatory arena in Sacramento on behalf of community associations. So I have the honor, our firm has the honor of being the advocate for CAI CLAC. And our job is to report to the executive committee, our delegates that represent each of the 8 chapters that we have around the state, monitor and advocate on behalf of community associations for legislation and regulations that impact California.
And some of that involves, I know from experience and hearing you speak every year, not just creating laws and trying to get new bills passed to help community associations, but also trying to mitigate any of the bad laws that are going through that could have a negative impact on community associations, correct?
Yeah, that's absolutely correct. In fact, some of the bills that we're going to be talking about today are bills that we as CLAC sponsored, meaning our communities came up with the ideas. We then took those ideas to state legislators, asked them to author the bill, and then move the bill through the process, negotiating various elements of that. Other bills were brought to us by legislators that either heard from constituents or had personal interactions with HOAs or boards and brought their own legislation to the table, which we then react to and try to negotiate in the best fashion we can.
Perfect. Thank you so much. So we're here to talk about some of the major legal updates from this past year, 2024. And I think there are about 6 of them that we got to step through. So how about we start with Assembly Bill 2159. When I say AB 2159, that's Assembly Bill, SB is Senate Bill. So 2159 covers electronic voting. There are a lot of aspects of this to consider. So could you kind of unpack some of the key rulings?
Well, AB 2159 is an example of one of those bills that we sponsored. Every fall, CLAC brings together a number of delegates and representatives at an annual planning meeting and talks about what we want our agenda to be for the following year. So in October of 23, our delegates came together and said, let's pursue electronic balloting. CLAC had pursued it about 10 years ago, and it stalled in the legislative process. Since that time, 27 other states have adopted some form of electronic balloting. And so that gave us some good momentum. It also gave us some laws that we could cherry pick from. And so while this is pretty complex, and Steve can go through some of the details that associations and boards need to be aware of, very little of it is brand new. We end up taking pieces from Florida, we took pieces from Illinois, we took some pieces from Nevada, and really try to take those elements that we thought were needed in California, either due to legislative concerns or constituent issues, and put them into this bill. When we first started the bill, it was really one change to one section. We just wanted to add the word electronic. It became more complex as we went through the process, simply to ensure that voters had protections like they do with the written ballots, that there was secrecy, that there was transparency, that the boards had a process so that members could be informed. So it did get much more complex, but because of the abilities of good guys like Steve and others, they're going to be able to hopefully make it a smooth transition for associations.
That sounds very California. You want to change one word and it gets a lot more complicated. Steve, can you expand on what this means for us?
Yeah, so this is interesting because for those of you community managers or board members that have been working for some time, you've seen kind of this trend over the last few years where we've had to respond to statutory changes that the legislature has made regarding our elections. It's been a hot topic for a while. Different procedures that we can utilize, new notice requirements. Much of what's in the electronic secret balloting procedures now as a result of this statute still aligns, as Louis said, with that. And I think it's because mainly it's that the idea of electronic voting really should be considered the idea of, no, we're still using secret ballots. It's just that now we have secret ballots that are written secret ballots that we do through the mail, or electronic secret ballots that are inspectors of election process on an internet platform, right? That has to, maintain the identity or the anonymity of the voter and use certain security standards. So it's really the same thing. The difference is that now when we're doing electronic secret balloting, if we're going to have the option and utilize an election electronically, and by the way, the election can be conducted in both manners. You can have written ballots and electronic secret ballots. It doesn't have to all be one way. In fact, in some instances, you might have to do both because members have the right to either opt in or opt out of doing the electronic thing. But when we are doing electronic secret ballots, there's a new notice requirement that goes out. And this has to be an individual notice, right? That's either emailed or mailed to each member's, basically saying how to obtain access to the e-voting platform and how to vote by e-ballot. And that's what I mean by, electronic secret balloting. I think procedurally, the biggest thing that boards and managers should be aware of is one, in order to conduct these elections, it's not just finding an inspector of election that's capable of doing this, but a lot of effort has to be made to actually develop the role of voters that have either opted into electronic secret balloting or have not opted out of it, right? Because that in itself is significant because we have to maintain that list of those people that has to be included on the member list that's posted. So that opt-in and opt-out procedure that's utilized is very important. Our firm, what we're advising our clients to do is there's a statutory change made a few years ago that allows, members to essentially opt into receiving association notices electronically. So for the communities that have done that, and that was a welcome change to the law because obviously it cuts down on the costs associated with paper and all that good stuff. But for those communities that have had these members and they've developed a list to receiving association notices electronically, we're drafting our election rules to say all of those members, we're treating you, if you've already opted into receiving electronic notices, we're going to treat you as already have opted into conducting your vote electronically using an electronic secret ballot. And then we provide a process for them to opt out. So it's, this is something where you do have to work with council, management, and the board to understand it. But the big picture I want to get here is that it's not just finding an inspector of election that can do an e-vote. There's got to be efforts made well in advance to say, okay, what does our role of e-voters look like? And how do we facilitate getting more people to consent to opting in to doing an e-vote so that we can hopefully reach our goal of having the election done entirely electronically and not having to send out written ballots at all.
So these are rules and procedures that the board needs to adopt. How are we going to treat this going forward? And then making sure they do that uniformly.
Yeah, exactly. Yeah. So it's, you have to work with your council. And it kind of sounds self-serving, right? But we've had every year, it feels like for the last 3 or 4 years, right at the beginning of the year, just a rush of clients saying, oh, the law changed again. We need council to update our election rules. And now we're going to be in another, and we did it last year or the year before to deal with elections by acclamation. That was Lord Davies' bill, I believe. And now we've got electronic secret balloting. So yes, you do need to update your election rules in order to cover this process. And during the process of that update and working with your council, I think the board management will be educated and made clear of, okay, what procedural components, are there and what do we need to do? It's important to understand this though, right? The law still prohibits election rules from being amended within 90 days of an election. So this is not something that, communities should necessarily wait on. If they've got an election, in June, July timeframe of next year, the time to start is now, making sure that these things get on the books because we have to, start the notice process and all that good stuff beforehand.
Fair enough. Thank you so much. Moving on to AB 2460. That's the quorum requirements, right, Louis?
Yes. And AB 2460 is an example of kind of a significant number of legislation that happens these days. This is really a cleanup bill to a piece of legislation we passed 2 years ago, which was AB 1458, which was the initial piece of legislation that allowed for a board to call for a subsequent meeting if they didn't achieve quorum for a board of directors election. There are some issues with that we found right after it was signed and through the process of implementing it. So we went back to Assemblymember Taw and asked him if he would run another bill to help us clean it up. And so it may not still be perfect. I don't know that there's anything as perfect legislation, but what the intent of 2460 was to really provide some clarity in some areas that were kind of vague. And then once we got into it, we did notice, as many people have looked at the bill when it was going through the first iteration, there were 4 different places in the original bill that talked about a reduced quorum, and each one of those defined it different. So if we did do anything,
problematic.
Exactly. If we did do anything, it is now consistent in all 4 places using the same words, commas, etc., of what that reduced quorum looks like.
All right, Steve, what does that mean for our boards?
Yeah, big picture, and I like this bill, right? The intent is this, right? Associations, right, for their membership meetings, in order to conduct those membership meetings, the most important of which being the election of directors, there has to be quorum that's reached. And quorum is basically, the minimum amount of membership that has to participate in a meeting, right? Cast a ballot in order for the meeting to actually be held. And for some communities that had a high quorum amount, they would be in a situation where year after year after year, they weren't even able to conduct an election of directors simply because they weren't able to achieve quorum. And there's a possibility to amend your bylaws to reduce that quorum amount, but that in itself requires a membership election. So associations, hey, we don't have enough participation in our director elections. How do we fix that? Well, you have to amend your bylaws, which requires even more participation in that amendment vote than your director election to begin with.
So catch 22.
Yeah, exactly. So Senator Todd looked at this, and now what we do is we have a statutory reduced quorum amount. So those associations now, you can't reach quorum for your director election, right? And specifically for a director election. The association can call a reconvened meeting, right? Basically adjourn the meeting and try it again, and that quorum will step down automatically to 20% of the membership, right? Which is great.
So regardless of what your governing documents say, it's 20%.
But there's a catch to that. Some associations have quorum amounts, reduced quorum amounts that are even below that. In that case, those associations still follow their bylaws. This law doesn't affect that. This is only for those associations that have a reduced quorum amount in excess of 20%. The statute now brings it all the way down to 20%. So it's a good bill. And I have a question for Louis on this, because so many times, we as attorneys, kind of, once the laws come down, we have to explain them. Like we have our firm's big symposium next month, and we're doing these things. So many times we see these bills get passed. We're like, well, wait a second, there's just so much ambiguity here. And then there's a cleanup bill, and then sometimes 2 cleanup bills. I would love to hear from you. Just why is that so often the case? Because I assume some of these concerns are brought up during the review process at the time the initial bill is proposed and being amended. Can you give us some clarity there on that?
Well, actually, I think some of it comes about, Steve, because some of the practitioners in the field really don't engage or monitor the legislation as it's going through the process. And so there are no, practitioners per se of HOA law in the legislature. And while we do our best to utilize experts throughout the process, it's usually pretty fast moving. And once we make one change, it's hard to go back and make another change to it. So the process becomes cumbersome. And, I'm aware of at least some of the email threads that happen, especially after legislation amongst HOA attorneys. And I think really kind of what happens is after a bill gets done and people are sitting there looking at it, how we're going to implement it, is when that kind of feeding frenzy starts and says, oh my God, we missed this. Oh my God, we missed that. And that gets us back into this kind of cleanup cycle that we do.
At that point, it's too late. That ship has sailed.
Yeah, that's right.
Now, Steve, just before we move on, you mentioned that this is specifically for board of director elections, nothing else, right?
Nothing else.
Okay. So you don't get to change other guidelines in the CC&Rs by this reduced quorum.
Exactly. Yeah, you can't. But I mean, usually director elections are what apply to, to quorum, but but all the other types of votes that membership meetings are called for in a membership meeting is when the membership meeting is being called to direct the corporation, the association, one way or another, right? To direct the election of directors, to direct an amendment to the CC&Rs. All of the other types of elections that we have usually aren't based on quorum. They're based on voting power. So regardless of quorum, you need 2/3 of everybody in your community to send in a ballot that says yes on the CC&R amendment, right? So that it wouldn't affect this. And then in other scenarios, like to approve an assessment increase, right, or a big special assessment, that quorum is actually set by statute already. So in this scenario, it says, yes, it applies only to director elections, but in reality, this is the only scenario in which something like this would apply because everything else is kind of dictated by either their governing documents or existing provisions of law.
Fair enough. Let's shift to AB 2114, balcony inspections. Louis?
AB 2114, balcony inspections. Balcony inspections, I think, is something that many associations have been aware of. There is a deadline for the initial balcony inspections to come January 1.
Of 2025. So in about 2 weeks.
That's right. There was no delay in the initial inspection deadline. What we had heard was that there seemed to be a backlog or an inability to find inspectors. And the original bill was written with a very narrow scope, basically architects and structural engineers. And so what we did is we went back and expanded the pool of potential inspectors. What makes this bill unique among the others is that it went into effect on July 1, 2024. That's because we added an urgency clause to it. There are issues that happen in the legislature that demand immediate attention. And so if they reach a certain threshold for that urgency, you can add this special clause to a bill. What it does is it kicks up the voting threshold. So most bills go through needing a majority vote. Yeah, an urgency clause, it needs a 2/3 majority in order to pass, but it becomes effective the day the governor signs the bill. So because we knew the deadline was looming, we knew that associations needed this help immediately, we were able to meet that threshold for an urgency clause and add that language to this bill so that civil engineers were then authorized and able to conduct those inspections the day the bill was signed.
I think our listeners may be confused because you used the word urgent and legislature in the same sentence.
More times than not, we prefer the legislature not act. But there are times when we need them
Fair enough.
In an expeditious fashion.
Steve, what does this mean practically?
Yeah, so those of you that this sounds new, I mean, this applies to condominium developments, right? This is you have to do the inspection of your exterior elevated elements, right? These are places that we call it the balcony bill, but it's not just balconies. It could be elevated walkways or decks or anything along those lines that are at least 6 feet off the ground, meant for people to walk on or to have it, and that rely, entirely or substantially on wood for their structural support. This AB 2114, the modification of the balcony bill, what it did was serve to amend or to include an additional class of professional that can conduct the mandated inspection that's due by the 1st of next year. But this inspection requirement, Louis probably knows off the top of his head, it was 4 years ago. I feel like we've been talking about this, right? This law has been in effect. So we've had all this time. And I remember when the bill first came down, we spent a significant amount of time, and I know a lot of people in our industry did, telling associations, yes, it's not due until 2025, which seems like forever in the future, but get it done now because people are going to be scrambling in the 11th hour and, the available inspectors aren't going to be as available. And if they are, the pricing is going to go up. Same thing if repairs need to be performed. Basically, just don't delay. And I think that this bill my guess is, and Louis, correct me if I'm wrong, kind of a response to the fact that some of the issues that people are running in, that they have waited so long, because before it was just architects and structural engineers that conduct these types of inspections. So now legislation, okay, we need more inspectors. Civil engineers are sufficient to do this too. So let's add that in there to get these associations the ability to comply. So that's where it is now. But this is a significant thing for condominium projects. It's, there's some expense involved, but this was, the impetus of this legislation entirely was that Berkeley balcony collapse, where, I think 20 students fell and a few lost their lives. So the legislature responded with making sure that both apartment projects and condominium developments are properly inspecting these elements, not just, having your reserve analysts say, yeah, how long is it going to last? But these are more significant inspections, making sure that the waterproofing elements and the structural supports are safe. And that's why I think it's a good bill. I think it's forcing associations and their boards to do really what their job is and to make sure that their physical assets are being properly maintained. The clock is ticking. We got a couple weeks left here. And now at least we have civil engineers that can help perform the inspection.
If folks don't comply by January 1, 2025, as they're supposed to, is there a penalty that will be imposed?
Yeah, there's statutory penalties that can be imposed, but the bigger issue too is liability exposure, associated with it as well. I mean, if there's an issue with a balcony, right, not only and heaven forbid someone gets hurt or loses their life, right, not only is there potential, coverage in terms of the association's exposure for that injury, but now, right, the board of directors, right, they've been operating under the standpoint now that we've had to do these inspections, they failed to do it. Now it's a full-blown negligence claim, right? So the amount of liability exposure that the corporation bears as a result of not even meeting this deadline that's been in place for years now is something that's concerning.
Interestingly, none of the insurance carriers have begun asking if folks are compliant with this balcony inspection bill.
Really?
Not a single one. I expect that may come down the line, but currently nobody's asking. So they should still offer defense, hopefully. Let's move on to SB 900, which is a bill that covers repair and maintenance. Louis?
SB 900 is one of those bills that we did not introduce. Frankly, you'll be surprised at how many bills get introduced because constituents raise issues with legislators. And this is a perfect example of that. There was an older association. It was an apartment conversion and very old, but this association also had written into its documents that they were responsible for maintaining services through the common area like gas lines. And so did they maintain them? No. Did they break? Yes. And so when they broke, there was this huge controversy over who had responsibility for what. And of course, the association also didn't have reserves to fund the repairs. The board members weren't sure what they were doing, so they were refusing to meet. And so a whole lot of issues. And so what happens when homeowners get upset? They call their state senator. And when a state senator answers the call and sees something like this, they get engaged in how do they fix issues? By running legislation.
Unless it has to do with fixing the wildfire insurance issue, and then nobody does anything, right?
Well, good point. Good point. So that's how this bill came about. Was Senator Umberg said, this is crazy. We need to fix this issue. The way the bill originally was created was to say that if there was some major disruption in service that the association was responsible for, that all repairs had to be concluded within 10 days. And obviously, that's just not possible for anything. So this was one of those examples where we sat down with the author. We negotiated with him. He's the chair of the Senate Judiciary Committee. We knew we weren't going to stop the bill. So at the end of the day, it's not a perfect bill again, but I do think that there's some elements that were added into this bill that could be helpful to associations going forward. And, again, one of those things that we didn't have any say in the beginning, but our process and our ability to interact with the senator, I think, made the bill less bad.
Steve, can you unpack that?
Yeah, well, okay, so big picture, where there is an interruption in gas, heat, water, or electrical services, right, that begin in the common area and that either affect the common area or that extends into a separate interest, meaning a unit or its exclusive use common area. Hey, I live in my unit and I don't have electric anymore because there's an issue with the electric line out in the common area. Now, association boards of directors are legally compelled, right, to commence, I'm going to quote the language here, commence the process to make the repairs necessary to restore that utility service within 14 days. And it is a question I have for Louis. I mean, I'm sure hopefully it was talked about what is commence the process to make the repairs. Does that mean call a board meeting at which time proposals will be reviewed? Does that mean the day that an actual contractor is out there starting the work? Do you have any insight on that?
Yeah, I think it's all of that or any of that, Steve. We went back and forth on this, on how specific to be with that type of language. And ultimately, where we landed and were able to get the senator to agree was to leave it a little bit vague, so that an association, based on the situation, could actually, say in some board meeting or whatever, we're commencing the process, and then give them cover to make that happen, because we know these types of situations could differ in any number of ways. And so we preferred the vagueness, frankly, when it came down to the negotiation.
I hear you. Yeah, it gives you some leeway. Personally, I know this isn't one that our industry, proposed. I don't necessarily on the substance mind this. I see too many boards get in a circumstance where, hey, utility service was disrupted and a repair needs to be made, and what they want to do about it is kind of go back and forth with the owner, saying, well, whose responsibility is it? And so much time goes by. We always say, hey, listen, just get the situation fixed, right? And then figure out as you're doing it whose responsibility it is. In virtually every set of association documents, if it ends up being the owner's responsibility, there's mechanisms by which the association can bill the homeowner for that. But sitting in a scenario, we see associations get sued all the time because they spend months arguing about whose problem it is when the homeowner doesn't really even have access to the areas that need to get fixed in the first place. So this is a scenario in which when there's a utility service that's disrupting the use of a unit, and it starts in the common area, the association, has to do it and address the matter as soon as possible, essentially. And if the association doesn't have the money, there's a mechanism now that it allows the association to obtain a loan without requiring a vote of the members. Right. So most of the times in sets of CC&Rs for the association to borrow money, there has to be a vote of the membership. Now there's a statutory basis on which they can borrow money for this purpose without having to go to a membership. And on top of it, levy an emergency assessment to allow for repayment of the loan. So the legislature, how I interpret it is, hey, boards, when something like this pops up, you need to address it immediately. And we are going to get rid of every excuse you possibly have to drag your feet on it, because if you don't have the money, we're going to give you the access to the money. If it requires membership approval under your documents, we're going to waive that requirement for you, which I think is a good thing.
Steve, you mentioned loan. Could they use reserves to fix these things?
Yeah, absolutely. They could use reserves to fix these things. Interestingly, this bill now actually mandates that these types of components, these water, heat, electrical, gas components, actually be listed now as major components, meaning they have to be incorporated into an association's reserve study, which is a roundabout way of saying, Ryan, yeah, the legislature says not only can you use reserve, you should be reserving for this stuff anyway.
Which I think everybody in the industry would agree, you need to be reserving for the replacement of your electrical and your pipes, because we're now seeing these 60-year-old condominiums with these aging components failing time and time again, and nobody has the funds to replace them. It's very expensive. It's very time consuming.
Yeah, absolutely. And I mean, this is another scenario that's really affecting condominium developments, and for another reason as well, right? There was a bill either last year or 2 years ago where the legislature has tapped the California Building Standards Commission to come up with regulations basically mandating the installation of a certain amount of electric vehicle charging stations in multifamily environments at a few years in the future, anytime a permit gets pulled. So big picture, condominiums, understand it's coming down the pipe. At some point, if you don't have EV charging stations within your community, the legislature and the Building Standards Commission, through regulatory authority, are going to compel you to install EV charging stations, which might not be that expensive just for the stations, but most associations that are concerned about this and that we see don't have the electrical infrastructure to support these stations. So we're already telling them they should be reserving for upgrades to their electrical infrastructure. And this is kind of another reason why it's actually fortunate that the legislature now is specifically putting it in there, because now there's another basis with which they should be considering it.
I feel like that's a whole nother podcast. We could talk about discussing the electrical vehicle charging stations and the dangers that those batteries in the garages have. So we won't get into that. We're on a time schedule here. But let's move on to SB 428, which is the workplace restraining orders.
So this is one of those that comes about just because associations are businesses. And this, again, we didn't bring this bill forward. We engaged on this bill just a little bit, but really this is more of an informational matter that we've been providing to associations because they are businesses. And we know that, especially in our form of business, there is a certain level of harassment that sometimes takes place. And this is really, I think, and I'll let Steve get into it just a little bit more, but I think is a benefit for us as employers to help protect our employees in certain situations that might arise.
Steve?
Yeah. So HOAs are considered employers, right? So as employers, they have certain, remedies and certain obligations to protect, their employees from workplace harassment, right? And their employees extend to their volunteer leadership and their elected leadership, right? So their boards of directors, their committee members, in addition to their managing agents, even though the agent might be, employed by an independent management company, and independent contractors as well. So what this does is it enables associations to make it easier for them to obtain restraining orders on behalf of the people that are helping to run the community, that are getting harassed, that are getting subjected to a course of conduct, right, that seriously alarms, annoys, or harasses the person. That's how it's defined under the statute, and that serves no legitimate purpose. So if you've got, members, and unfortunately we're seeing this more and more, that are real bad apples that really want to make it, their mission to persecute a contractor or committee member of the association, there's a clear basis now by which the association can obtain a protective order against that individual to protect their volunteer.
And not only are they able to, but they have an obligation to obtain that on behalf of the board of director or the committee member that's being harassed, or the contractor.
Exactly. Yeah. The HOA can be subject to liability if they don't take measures to protect them. So, it's another basis in which to do it. And this is, my thoughts are kind of mixed on this one. I have a lot of sympathy. I mean, I think our firm just this year, unfortunately, almost a dozen types of protective orders we had to get. It just seems that people are pretty venomous. I mean, we teach a lot of programs on like de-escalation. And we don't want to see more of those. And I'm concerned now this might be a situation where, volunteers that, anybody who runs for their board of directors or committee members understand that when you're signing up for that job, you're not going to get thank yous all the time. There's going to be members that, regardless of what you do for them, are going to be upset about it. And sometimes they don't say the nicest things. At what point does that kind of trigger a harassment scenario in which, the association is now compelled to get involved and obtain some type of order? We don't know yet. So I'm still mixed on this, but we'll see.
But at the end of the day, consult legal counsel if you have anything approaching this.
Yeah, absolutely. I mean, as volunteer boards of directors, even if you are an attorney, right, when you're serving on the board, you're serving in the capacity of a volunteer. And what the legislature wants you to do as part of your duty of care is to rely on the advice of your experts, right? So insurance issues, you talk to the Ryans of the world, right? Legal issues, legal concerns, you talk to your legal counsel. And that's really the approach that you should take when anything comes up. And then you rely on the advice of your legal counsel. And if that advice is right, great. If it's wrong, it's not your issue. You've justifiably relied. You've done your job as a fiduciary for your association.
Business judgment rule. I love it. Mm-hmm. Lastly, Corporate Transparency Act. We did a podcast on this with Natalie Stewart. It's on everybody's mind, which, from what I understand, it's a pretty quick process. You could comply pretty quickly. Steve?
Yeah, there's companies that are popping up, right, that allow that facilitate the process of submitting these beneficial ownership information reports. We don't recommend that boards try to do them themselves. Everything has to go on one report. There's a variety of reasons why. So these companies, it's kind of like submitting for FHA certification, right? These companies are there for a very reasonable fee. Will handle that whole process.
Yeah, fair enough. Steve, is there any case law that we should discuss that might impact community associations?
There's just one case. It was a case, it's the Doskitz case against an association collection service provider within California, and it dealt with how we apply assessment payments. So our firm, we have an affiliate company, Altera, that does assessment collection work. We work in this area a ton, and it's been interesting to see all these court cases that have come down, because unlike other areas of the law that have been impacted by statutory changes by the legislature, there really hasn't been much that's affected assessment collection. What's actually affected assessment collection are cases like this. So this is case law, not the California legislature acting. So a while ago, right before a different case came down years ago, when a homeowner was delinquent and they would submit a payment, and that payment was only a partial payment, it wasn't enough to pay off the entire balance, the association or its collection entity would reject it and say, no, you have to pay us everything. Otherwise, we're going to keep going. And that was kind of the standard process until it got challenged. And then it went to court, and the appellate court stepped in and affirmed this decision that basically said, no, and looking at the Davis-Sterling Act, the associations cannot reject a partial payment. If a homeowner submits any payment, we have to accept that payment. And not only do we have to accept that payment, we have to apply it in accordance with what the Davis-Sterling Act currently prescribes, which means if I give the association $1,000, right, that $1,000 first has to go towards my assessment balance. And then anything that's left over after assessments are paid off, can it pay off late charges, interest, collection fees, collection costs, right? That's Civil Code Section 5655 that requires payments to be applied in that order. Fast forward to where we are now, this case dealt with a scenario in which a homeowner wanted to enter into a payment plan, right? So, okay, I'm delinquent. I don't want you to continue foreclosure action. I agree to go into this payment plan. And as a condition of getting into the payment plan, the collection company made the homeowner basically waive their rights under Section 5655 in terms of how assessments are applied. In other words, saying, homeowner, when you give us a partial payment pursuant to your payment plan, we can use that money to pay off collection fees first and to pay off interest first before we pay off the assessment balance, right? So it was a 5655 waiver. It made the homeowner waive their rights. This got challenged as a violation of the Fair Debt Collection Practices Act and California Unfair Competition Law. And it was ultimately the homeowner who challenged it ultimately won. And the court looked at it and said, no, this allocation of payments serves an important public purpose of protecting homeowner equity, making sure that their assessments are paid down as a first priority. If we allow a waiver of this provision, it would flout the very purpose of Section 5655, right? So that the court ultimately held that those waivers are not lawful.
All right. Well, thank you both for joining us today. Louis goes around to all of the chapters in California every November and does this legal update with attorneys from the various chapters, the 8 chapters in California of CAI, which is always good to pay attention to. But if you can't, we're going to try to put this on a podcast every December so you can find out from us. Thank you guys both for joining us. Where can our listeners go to reach you if they want to learn more about your firm, Steve?
You can just go to tinleylaw.com, TINNELLY law.com, or our online web law library is findhoalaw.com. You can go there and it'll take you to other sites as well.
And Louis doesn't want our listeners to reach out to him. He works for CAI, the Community Association Institute. So if you want to reach Louis, get involved with CAI, and that's how you'll reach Louis. Thank you guys for joining us. As we end our episode, I'd like to remind our listeners that if you have any comments, questions, or suggestions for topics you'd like to learn more about, email us at feedback@hoashow.org. Join us next time on The HOA Show.
To share or subscribe to The HOA Show, visit us at hoashow.org. There, you'll be able to listen to other episodes, find helpful resources relating to HOAs, provide feedback, submit questions, and check out other great stuff. The HOA Show podcast has been made possible by the contributions of Klein Agency Insurance Brokers, leaders in the community association industry. The views and opinions expressed by the podcast, its presenters and guests, do not constitute legal advice. For more information on how the topics in discussion apply to you, please consult with your own legal counsel.